prayer for us.
Very well, Minister. Shall we pray? Lord, we thank you for the privilege of working on behalf of the nation. As we gather to deliberate on the proposed custom law, we pray for fresh insight, we pray for wisdom, we pray that we can concentrate and focus on what we need to do in order to achieve the goals in service to people. Pray especially for our chairman and all members, as well as the technical staff who support us. We ask, Lord, that you will always enable us to do what is right by you and by extension, the people you have entrusted us to serve. Amen. Not hearing you, Chairman.
We've been making very good progress in this joint select committee and looking forward to further progress today. Before we go into apologies for absence, I just want to recognize a change in the composition of the committee and recognize a resolution that was moved in the Senate for Senator Janice Allen to replace Senator Sophia Fraser-Binns. And as such, I'd like to welcome Senator Janice Allen to this committee and look forward to your contribution.
Thank you,
Madam
Minister.
Thanks, Senator. Madam Secretary, do you have any apologies for absence? Kamisha Bailey, do you have any apologies for absence?
Yes, Chairman, we have apologies from Senator Johnson Smith, Senator Donald Webby, Minister Favour Williams, and Senator Hill indicated that he will be late.
Okay, thank you. The minutes of the meeting held on May 27th, Thursday, May 27th, have been circulated. Do we have any suggested changes to the minutes? Any changes on page 1 or page 2? Pages 3 and 4?
One correction, Minister.
Mm-hmm.
It has to do on page 4, the last paragraph, the second line. I believe that should be commissioner. You see the word commission there?
The page 4?
Page 4.
Last paragraph.
The last paragraph, beginning with the words member done.
Yes.
And
Second line,
down,
commissioner. Yes.
Second, yes.
Yes, I agree with you on that. All right, page 5. Page 6, 7, and 8.
Minister,
Yes.
I'm not looking now on the minutes, but when you get to clause 30, there were some discussions that included and some follow-up action from you to discuss some aspects of the provision.
Yeah, clause 30 is a longest part of the minutes, member. So I think what is captured here, and we will be able to get to it.
Okay.
Okay.
Yeah, that's just flagging that.
Yeah, maybe not right away, but all of these things are being flagged. Our appreciation of some of them, I think, will be broader as we go through the bill. But that's captured here in the minutes.
Okay.
Okay. So if there are no more amendments, can we put the minutes to the committee for approval with amendment on page 4 as has been highlighted? All in favor?
Aye.
Okay, I declare the motion for the acceptance of the minutes carried. With respect to matters arising from the minutes, under that clause 7, clause 30 rather, on the designation of customs, of places by commission of custom. What I'm proposing to do, Member Hilton, just given the volume of the bill and the volume of things that we're going to have to come back to. What I foresee is that we're going to go through the bill and we might have a session or 2 or 3 where we go back and look at things that had detained us for some time, hopefully with a broader appreciation and broader perspective.
Mm-hmm. Okay.
So with that agreement, we would now move to the section of the meeting where we go clause by clause. We had finished subpart B the last time, which took us to clause 46. So we begin at clause 47. Who will do the honors for us in terms of reading the bill?
Paul Corbett, Senior Legal Officer, Jamaica Customs Agency.
Okay, well, thank you. So thank you. All right, over to you.
Subpart C, reporting requirements for vessels and aircraft. Clause 47, passenger information. 1, the Commissioner may, by notice in writing, require a carrier to submit to the Commissioner all information specified in the notice, being information A, that is included in the passenger name record of a person referred to in subsection 2, and B, that the carrier holds, whether in Jamaica or elsewhere, or has access to. And a carrier who fails to comply with the notice commits an offense. Two, the persons referred to are persons who A, have arrived in or departed from Jamaica on or after the specified dates, B, are arriving in or departing from Jamaica on or after the specified dates, or C, are intending to arrive in or depart from Jamaica on or after the specified dates on board the vessel or aircraft. 3, where information is required in respect of a date under subsection 2, the information shall be provided to the Commissioner within the time specified by rules. 4, for the purposes of this section, the specified date is the date specified in the notice. 5, a notice under subsection 1 may specify A, the form and manner in which the information is to be provided, and B, any relevant additional information to be supplied. 6, for the avoidance of doubt, nothing in this section requires a carrier to provide information that the carrier holds or has access to about an employee unless the information is of a kind that is also generally held by the carrier, or to which the carrier generally has access in relation to its passengers. 7, the Commissioner shall not retain information provided under this section for longer than the prescribed period unless A, all identifying particulars are deleted from the information, or B, the retention of the information is required for the purpose of 1, investigating and prosecuting an offense under this act or any other enactment, or 2, national security. 8, in this section, passenger name record means the travel information in the carrier's departure control and reservation system as relates to the person.
Chairman,
Yes.
I am Trying to find the opportunity. Yes, to raise my hand to indicate that I wasn't readily locating it. The technical team just wanted to raise a query with the CPC. We were not sure whether looking at 47.1b, the latter phrase, and the carrier who fails to comply with the notice commits an offense, whether that ought to go back to the margin or if it is to be as it is there. We're reading it and we weren't quite sure. I thought I'd raise it.
Yes, it appears
in terms of
error. Those words should be back to the margin of the subsection.
All right, very well.
Okay, please continue.
Clause 48, exemptions. The commissioner may, by notice in writing, subject to such terms and conditions as the commissioner thinks fit, exempt a carrier from complying with some or all of the obligations under section 47, if satisfied that A, circumstances exist which would render compliance with such obligations by the carrier unlawful under the laws of the country where the carrier is established, or B, compliance with such obligations would contrary to an international agreement to which Jamaica is a party. Clause 49, collection of travel information by commissioner. 1, for the purposes of A, customs processing of persons under this act, or B, monitoring the movement of any vessel or aircraft and goods and persons aboard vessels or aircraft. In order to enforce the customs laws, the commissioner may collect any information referred to in subsection 2. 2, the information referred to in this section is A, information from the carrier as to the details of the movements of the vessel or aircraft. B, information from a person arriving in or departing from Jamaica as to the person's name, date of birth, sex, passport number, nationality and travel movements, and any other relevant information pertaining to the person's identification or the person's movements while in Jamaica. Clause 50, advance arrival and departure information. 1, a carrier of a vessel or aircraft shall, before arrival of the vessel or aircraft in Jamaica, or before its departure from Jamaica, as the case may be, submit to the commissioner in the prescribed form and manner a declaration that includes the following information. A, the estimated time of their arrival or departure of the vessel or aircraft. B, the customs controlled area at which the vessel or aircraft will arrive or depart, as the case may be. C, a list of the cargo for discharge within Jamaica or for loading in Jamaica by the vessel or aircraft. D, a list of the cargo on board the vessel or aircraft that is not intended for discharge in Jamaica. E, a list of the cargo on board the vessel or aircraft that is intended for discharge in Jamaica for subsequent transshipment. F, a list of all passengers and crew on board the vessel or aircraft. G, a list of all stores on board the vessel or aircraft, including stores in the personal possession of crew members. And H, any other information prescribed by rules for the purposes of this section. And the carrier who fails to comply with this subsection commits an offense. 2, subject to subsection 3, the information specified in subsection 1 shall be submitted within the time prescribed by rules. 3, the rules shall exempt a carrier from the requirement to submit the information in the time required by subsection 2 if A, the distance from Jamaica to the port of departure of the means of transport concerned does not permit the carrier to provide the information within the time specified in subsection 2, or B, due to any other circumstances outside of the control of the carrier is unable to provide the information within the time specified in subsection 2. And those rules shall require the carrier to comply with such alternative arrangements as the Commissioner shall establish for the provision of the information in the particular case. 4. If the information required under subsection 1 or 3 is submitted by electronic means, the Commissioner shall ensure that a receipt is generated and transmitted by electronic means to the person who sent the information. 5. In the case of goods that are shipped in bulk, the information required under subsection 1 shall, unless otherwise permitted by the Commissioner, be provided before bulk is broken, and shall specify separately all goods that A, are in transit, B, are the subject of transshipment, or C, do not fall within paragraph A or B. 6, where information required under this section is not submitted as required, the Commissioner may withhold permission to depart from Jamaica until the date A, when the information is submitted to the Commissioner, and B, when the applicable penalty for non-compliance with the requirement to provide the information is paid. Clause 51, report and arrival and departure. Report of arrival and departure. 1, the operator of a customer.
Did somebody say something?
Yes, Chairman, I wanted to just note that these were provisions that have been the subject of comments by stakeholders. You will recall that questions had been raised in relation to the provisions at section 50 clause 52, 50 subclause 2 in relation to short transit, as well as
yeah, thank you for that. Yes, there had been comments as to if a vessel is less than 24 hours away, would they be subject to this requirement?
Right. We also want, it's important to the technical team to indicate that the provisions here at clause 50, as you know, they relate to advance arrival and departure information. These provisions were introduced initially in 2014 in the Customs Act by way of an amendment. And so they are being substantially reproduced here in this new piece of legislation. The move towards advanced arrival information is a key tool in customs risk management going forward. It enables customs to undertake improved risk management. It allows for better, more effective, and more efficient enforcement targeting. It facilitates shorter customs processing times because, of course, if customs has the information in advance regarding what goods will be arriving and how persons intend to treat with those goods, then customs can begin its processing before the goods have even arrived here in Jamaica. And of course, it facilitates pre-arrival processing. And this, of course, would enable customs, and you will see later that there are provisions that treat with that, allowing customs to do all the documentary review relating to goods, even before the goods have already arrived. So it means, of course, when the goods physically arrive in Jamaica, they can be almost seamlessly and very quickly removed from the ports and taken into whatever activity the person intends those goods to go into. The response of customs to the concerns that have been raised by the stakeholders in terms of short transit and short sea journeys had been that irrespective of whether the vessels are coming from a near port, it does not reduce the risk associated with it.
Yeah, I think we dealt with that when they mentioned it. When
right.
They before us and they mentioned it. So I don't think we need to rehash it.
Very well, Chairman. Yeah. But we also wanted to highlight that this was one of the key provisions going forward in the new legislation.
Chairman, I was there, participated in the discussion, but this, could someone remind me of, well, the person who spoke just before, could you remind, or you, Chairman, what was the resolution there and what the concerns are? What were
the resolution was that this is an integrally important part of customs operations going forward, that we already have it. And going forward, by having information in advance, it will improve, security and service. And this is standard. We're not doing anything here that doesn't obtain in other parts of the world.
No, the question was a practical. The sense of what I had was, I agree that these are standards. The question, as I thought I understood it, was, are there practical implications for a very short timeline? No, it's not obvious to me that should or should not be. So I just want to understand what are the considerations there, and if there is a sense in which it's too short and you can't get the information in the turnaround time, then the implications are that the goods or the vessel are held. Is that not the consequence, the outcome?
Ms. Edwards, you want to answer? Member Hilton?
Well, thank you, Chairman. It need not mean that the goods are held. It may result in slower processing times.
But
I won't think inevitably it's supposed to be held.
Right. May I ask you then, just since this provision has been in operation for some time, what has been the experiences? Have you had instances in the sort of short time frame situation in which that has occurred, and how was that handled?
Instances in which vessels coming from near ports have not been able to comply?
Right.
I wonder if, a moment, one of our...
If I may, Chairman?
Right.
Chairman? I'm not sure if the chairman is hearing me. I don't know if...
Yes, go ahead, please.
Go ahead. Marlon Louis.
Yes, go ahead.
So I just also want to point out that the bill itself in 50 subsection 3 does provide some amount of relief in terms of some amount of exemption. That is one. But secondly, we're talking about distance as against time. And it does not, because the time might be short, does not necessarily mean that you cannot conform to the report because of how shipping is done, whereby you have to book a vessel, book a port, you have to take person shipment and so on. So in fact, in most of the cases, the carrier is well in advance, can report, and we have a high level of compliance as a result. In terms of the question that Member Hilton asked, yes, there are a few instances when persons are not able to comply. It might be because of transmission issues also. And of course, they will use a provision in the Act and seek approval from the Commissioner. And in such cases, approval is normally given because of the particular circumstance. But it is not the norm, it is rare. And I think there are provisions in the current bill and this bill, as in 50 subsection 3, that provides for that.
And so you've had resolution under the exemptions, and Is that's the answer to my question? Is that
correct? I'm saying that it is provided for in law, and in those few cases, it is used and it is done.
okay? So you've had no protracted issues.
No.
Resulting. Okay. All right.
Yeah, Mr. Chair, should I continue?
Please go ahead. Yes.
We're at clause 51, subclause 1. The operator of a customs controlled port or other customs controlled area at which a vessel or aircraft arrives or departs, as the case may be, shall report to the Commissioner the fact of the arrival into and the fact of the departure from Jamaica of the vessel or aircraft, and an operator who contravenes this subsection commits an offense. A report of arrival or departure under subsection 1 shall be submitted within such time as is specified by rules. Clause 52, no loading notice. 1, if on receipt of a declaration submitted under section 51, the Commissioner is of the view that the cargo contains any goods referred to in subsection 2, the Commissioner shall, by notice to the reporting carrier or that carrier's agent, warn the carrier, A, not to load those goods on board the vessel or aircraft or transport the goods to Jamaica. B, that should the goods be loaded or transported contrary to the warning, the goods will be detained on arrival in Jamaica and dealt with in accordance with the applicable provisions of the customs laws. And C, that any expense incurred by the Commissioner in dealing with those goods shall be paid by the carrier or the carrier's agent. 2, the goods referred to are A, prohibited goods, B, restricted goods in respect of which the enactment regulating the import of those goods has not been complied with, C, any other kind or category of goods as is prescribed.
Okay. What happens if the no load notice is received after the ship has sailed?
The proposed adjustment to treat with that, Minister, is to indicate that the inserting a provision, because we realized that that was an issue that had been raised by stakeholders, to insert a provision to indicate that the time frame for issuing the notice is to be stipulated in rules. And that would allow for it to be very clear as to when the Commissioner must issue this notice. And of course, if the notice is not received within that time frame, then the liabilities would not fall on the carrier for not complying with the notice. And we feel that that could resolve some of the concerns and give certainty to the industry regarding when they can expect to receive a notice.
Okay, thank you. So it dealt with in regulations.
So what it would mean, Minister, is that this provision we would propose an amendment here to insert a provision to indicate that the notice under 52, the notice at 52 is to be issued within the time frame stipulated in rules.
Okay, but you don't have that.
Can you just adjust the screen to bring back 52, please? Thank you. Right. Thanks. I do have the bill before me, but just for the screen purpose. Thank you so much, Chairman.
No problem. So, but you don't have that amendment on hand? It's fine. We can just make a note of that.
No, Minister, but it would be perhaps as a 52 subclause 3 to indicate that the notice at 52 1, under subsection 1, is to be issued within the time frame, within such time as is specified by rules.
Right.
Similar to the language used in relation to the other provisions.
Okay. All right, let's continue.
Clause 53, outturn reports. 1, an outturn report required to be submitted under subsection 2 or 3 shall specify in relation to the goods concerned, A, the list of cargo loaded or unloaded that exceeds or is less than the cargo listed in the advance declaration submitted under section 50, including the number of goods which are less or greater in number than the number stated in the advance declaration, or B, that the goods are fully accounted for as set out in the advance declaration submitted under section 50, as is appropriate to the case. 2, the following person shall submit an outturn report to the commissioner in respect of cargo loaded into a vessel or unloaded from a vessel. A, in the case of containerized cargo, the operator of the container terminal, and B, in the case of brick bulk cargo and containerized cargo, the operator of the wharf, where the cargo is, as the case may be, loaded or unloaded. 3, where cargo is loaded or unloaded from an aircraft, the operator of the customs control area where the cargo is loaded or unloaded, as the case may be, shall submit an outturn report to the commissioner. 4, a person required to submit an outturn report under this section shall submit the report within such time as shall be specified by rules, being a time no later than 48 hours after the cargo is loaded or unloaded, as the case may be, from the vessel or aircraft, and if the person fails to do so, the person commits an offense. 5, an outturn report shall show separately any cargo for which no transport document has been received. Clause 54, information from cargo aggregator. 1, the following information in respect of consolidated cargo arriving in or departing from Jamaica shall be reported to the commissioner by the cargo aggregator. A, the estimated time of arrival or departure, as the case may be. B, the customs control area where the cargo will arrive in or depart from Jamaica, as the case may be. C, a list of the cargo that is to be offloaded in Jamaica, or, as the case may be, that is to be loaded in Jamaica. D, a list of the cargo that is intended for discharge in Jamaica for subsequent transshipment. And E, any other information prescribed by rules. 2, the information referred to in subsection 1 shall be reported to the commissioner within such time as shall be specified by rules. 3, where there is a discrepancy between the quantity of goods specified in a report under this section and the cargo actually offloaded in Jamaica or loaded for export, as the case may be, the cargo aggregator shall, within such time as shall be specified by rules, report the discrepancy to the commissioner, and the cargo aggregator who fails to do so commits an offense. Clause 55, declaration and notice where advance report is made. Information in accordance with section 54 need not contain any details already submitted in A, the declaration under section 50 in respect of that cargo, or B, any separate notification already given to the commissioner. Clause 56, other reports in respect of cargo. Rules may provide for the submission of such additional reports as the Commissioner considers necessary for the effective customs control of cargo imported into or intended to be exported from Jamaica. 57. Form and manner of submission of or obtaining documents. 1. A declaration, notice, report, or other documents required to be submitted to the Commissioner under this part shall be A. Submitted in the form and manner prescribed by rules, and B. Be accompanied by such supporting documents as may be required under this Act or any other applicable law, and may be amended within such period as shall be specified by rules by the person who made the submission. 2. Where any time is specified under this part for the submission of any document, the Commissioner may, in accordance with rules, extend the time allowed for the submission of the documents. 3. Where any document required to be submitted to the Commissioner under this part may be obtained or confirmed by the Commissioner from another competent authority using electronic means, the Commissioner may waive the requirement under this part for the submission of the information. 4. In subsection 3, competent authority means an authority in Jamaica or another jurisdiction which exercises functions A. Analogous to those of the Commissioner, or B. Relevant to the information concerned. Clause 58. Disclosure of information in advance declaration. The Commissioner may, in accordance with rules, disclose to the operator of a customs control area any information contained in an advance declaration for the purpose of enabling the operator to make such reports as are required under the customs laws. Part 4, clearance and release of goods. Subpart A, temporary storage. Clause 59, temporary storage. 1. Imported goods shall be placed in temporary storage in accordance with this subpart from the time of their arrival in Jamaica until released for a customs procedure. 2. Goods required by this section to be placed in temporary storage may only be deposited at some place other than a place designated under Section 31D with the approval of the Commissioner. Clause 60, temporary storage declaration. 1. An advance arrival declaration under Section 50 or a report under Section 54 submitted in respect of cargo shall be treated as a temporary storage declaration for the purposes of this section. 2. The provisions of Section 12, subsection 3 and 4 shall apply to temporary storage declaration under this section as if the temporary storage declaration were a goods declaration submitted under that section. Clause 61, handling, etc., of goods in temporary storage. 1. Without prejudice to any rights that a declarant may have under this Act to take samples, goods placed in temporary storage shall be subject only to such forms of handling as are designed to ensure the preservation of the goods in an unaltered state without modifying their appearance or technical characteristics. 2. Notwithstanding subsection 1, the Commissioner shall permit such handling of goods as the Commissioner is satisfied is necessary for securing their removal from temporary storage for further transport. 3. The operator of the temporary storage facility where goods are stored under this Act is responsible for ensuring that the goods are not removed from temporary storage except in accordance with this Act, and for fulfilling all other obligations applicable to temporary storage of goods at that place. 4. Where, for any reason, goods cannot be kept in temporary storage as required under this Act, the Commissioner may, without delay, exercise any applicable power that the Commissioner may have to deal with the goods, such as destruction, sale, or confiscation. Clause 62, authorization for operation of temporary storage facility. 1. Person other than the Commissioner shall not operate a temporary storage facility for the purposes of this Act unless authorized to do so by the Commissioner. 2. The Commissioner may allow the storage of goods released for a customs procedure in a temporary storage facility without the goods being regarded as goods in temporary storage if the Commissioner is satisfied that A, an economic need exists which justifies such storage, and B, customs supervision will not be adversely affected. Clause 63, duration of temporary storage. 1. Except as provided in subsection 2, goods placed in temporary storage shall be cleared for customs procedure or re-exported within 30 days after their arrival in Jamaica. 2. Transshipped goods placed in temporary storage shall be cleared for customs procedure or re-exported within 90 days after their arrival in Jamaica. 3. Where goods are not cleared as required by subsection 1 or 2, the goods shall be dealt with in accordance with the provisions of this Act applicable to goods at a government warehouse. Subpart B.
Mr. Chairman. Mr. Chairman.
Go ahead.
There's an issue here that the technical team would wish to raise. As you would have noted, the provisions that treat with temporary storage are really clarifying. The language is new to the law, but they're really clarifying what actually occurs in practice and is of course consistent with the international standard. You'll notice that the time period for clearing goods is being moved from the current legislation provides for 14 days or such further period as the commissioner may allow to 30 days here. So the general principle is moving from the 14 to the 30 days. However, the current act does allow the commissioner to extend the time for clearing goods. We noted in discussions with stakeholders that they have raised some concerns about the commissioner no longer having that discretion. We also noted that since we had put this legislation before Parliament, Jamaica has become a party to the WTO trade facilitation, WTO agreement on trade facilitation. And we're constantly doing reviews to ensure that the legislation is strictly compliant. And when we double checked, we saw that one of the requirements is that the customs should have a discretion to extend the time that has been set for lodging of a goods declaration. And that is what not the TFA, I'm sorry, the Kyoto Convention in one of the general annexes indicated that we should have that discretion. And correction, since putting this legislation before Parliament, Jamaica has become a party to the Kyoto Convention, so not the TFA. And so in the circumstances, the technical team is recommending that there should be an adjustment at clause 63 to insert a provision to indicate that the time for clearing the goods from temporary storage at 63.1, as well as the transshipment goods at 63.2, should be either the 30 days or the 90 days as is now indicated, or such longer period as the commissioner may allow, or language to that effect, giving the discretion to extend the time and therefore bringing us strictly in compliance with what the RKC recommends.
Well, one of the purposes of this review is to make sure that Jamaica's customs laws and procedures are in keeping with international standards. And to the extent that, I haven't seen it myself, but to the extent that what you represent is the case, then, you know, certainly I believe that the committee would be in support of that amendment that you are, that you have put forward. Can we make a note of that, Kamisha?
I've noted it, Chairman.
Member Hilton, on board?
Yeah.
Okay. All right, let's move on.
Subpart B, standard clearance processes and requirements. Clause 64, goods declarations. 1, a goods declaration shall be submitted for a customs procedure within the time required by this act, along with such supporting documents as the commissioner may reasonably require. 2, a goods declaration may be either A, a standard goods declaration, B, a provisional goods declaration, C, a supplementary goods declaration, D, a simplified goods declaration, or E, such other type of declaration as may be prescribed in accordance with the provisions of this act and the regulations. Clause 65, persons who may submit goods declaration. 1, a goods declaration may be submitted by any person who is resident in Jamaica and is able to A, cause the goods to be presented to the commissioner, B, provide all the information required to clear the goods for a customs procedure, and C, ensure compliance with the customs laws for the customs procedure. An error there with the or.
Yes, Chairman, just a minor typo we seem to have there as 65(1)B.
Go ahead.
2, a person may submit a goods declaration notwithstanding being resident outside Jamaica in any case where A, the goods declaration is required under section 43(4), goods declaration by a person arriving in or departing Jamaica, B, the goods declaration is for transit or transshipment or the temporary admission of the goods, C, the commissioner considers the submission to be justified in the circumstances, or D, rules provide for the exemption of the residence requirement in that case. Clause 66, clearance of imported goods. The regulations may prescribe any class or category of goods to which simplified procedures for clearance and release may apply, and the procedure to be followed for the clearance and release of those goods. Clause 67, failure to submit declaration. 1, where A, in respect of any goods, a goods declaration is not submitted within the time required under this act, or B, goods are diverted, the goods may be dealt with in the manner set out in subsection 2. 2, goods to which subsection 1 refers may A, be dealt with in accordance with the provisions of this act applicable to goods in a government warehouse, or B, be treated as if they were cleared for home use in accordance with section 87(2). Clause 68, submission of goods declaration before arrival of goods. 1, a goods declaration in relation to imported goods may be submitted to the commissioner before the arrival of the goods in Jamaica in accordance with such terms and conditions as may be specified by rules. 2, the commissioner, A, may register, verify, assess, and process a declaration submitted under subsection 1, notwithstanding the goods have not arrived in Jamaica, and B, may, in accordance with rules, release the goods before they have arrived in Jamaica. 3, a release under subsection 2 shall be subject to such customs control as may be applicable on the arrival of the goods in Jamaica. Clause 69, clearance of goods destined for export. 1, before goods are delivered to the customs controlled area from which the goods will be exported, a goods declaration in respect of the goods shall be registered within the time specified by rules. 2, no goods shall be exported from Jamaica unless those goods are cleared and released for an export procedure. 3, the regulations may prescribe any class or category of goods that are exempt from the provisions of subsection 1 and the procedure to be followed for the clearance and release of those goods. Clause 70, failure to clear goods for export. 1, where goods are delivered to a customs controlled area for export, without any goods declaration having been registered for the export of the goods, the operator of the customs control area shall refuse to take delivery of the goods unless permission to take delivery is given by the commissioner in accordance with section 142(3). 2, if the commissioner is satisfied that goods have been exported without any goods declaration having been registered to clear the goods for export, the commissioner may require the exporter to submit for registration a goods declaration in respect of the goods. 3, subsection 2 shall apply without prejudice to any penalty or action which may be applicable in respect of the failure to submit the goods declaration. 4, goods found at any customs control area in respect of which no goods declaration is registered and which cannot otherwise be accounted for shall be dealt with in accordance with the provisions of this act applicable to goods in a government warehouse. Customs controlled area. Clause 71, amendment of goods declaration. If a declarant becomes aware, A, whether before or after the release of the goods in relation to which the goods declaration was made, and B, within 3 years after the date of registration of the goods declaration, of any incorrect or incomplete information in the declaration, the declarant shall promptly notify the commissioner thereof. 2, where a notification is made under subsection 1, the declarant shall, in any case where the goods are still in existence, A, apply to the commissioner in the form and manner prescribed by rules to amend the declaration, and B, include with the application to correct and complete information. Three, subject to subsection 4, a declarant shall be entitled, on approval of an application to do so, to amend any of the particulars furnished in the goods declaration at any time after the declaration is registered. 4, subsection 3 shall not apply, A, to any amendment that would render the goods declaration applicable to goods other than those to which it originally applied, or B, where the application to amend is made after the commissioner has notified the declarant that 1, the commissioner intends to examine the goods, or 2, particulars of the goods declaration are incorrect. Clause 72, withdrawal of goods declaration. 1, a declarant may request, in the form and manner prescribed, the withdrawal of the goods declaration in respect of the goods. 2, upon a request made under subsection 1, the commissioner shall subject to subsection 3, authorize the withdrawal of the goods declaration if the commissioner is satisfied that A, the goods are immediately to be placed under another customs procedure, or B, as a result of special circumstances, the placing of the goods under the customs procedure in respect of which they were declared is no longer justified. 3, a withdrawal shall not be authorized under subsection 2, A, until after the goods have been examined in any case where the commissioner has notified the declarant that the commissioner intends to examine the goods, or B, after the release of the goods, unless otherwise provided by rules. Clause 73, clearance and release of goods under customs procedure. With the approval of the commissioner, at any time before the release of goods declared for a particular customs procedure, those goods may be declared for another customs procedure. Clause 74, proof of declaration, etc. 1, the commissioner shall issue to a person who submits a goods declaration under this act an acknowledgement of receipt, therefore, in such form and as may be prescribed. 2, the onus of proving that a goods declaration has been submitted to the commissioner in accordance with this act shall lie on the person required to submit the declaration. 3, a declarant in respect of goods under customs procedure shall, upon request by the commissioner, provide proof that the goods have been dealt with in accordance with that customs procedure. Clause 75, release of goods. 1, no goods shall be released without the goods having been cleared for a customs procedure unless otherwise provided by this act. 2, the commissioner may refuse the release of goods for a customs procedure if such refusal is necessary for A, effectively implementing this act, or B, the protection of public health, the environment, national security, or public safety, and the agency of government responsible for the subject matter concerned so requests. 3, the release of goods in accordance with this section may be made subject to conditions, which may include conditions for ensuring that this act and any other applicable laws are complied with. Clause 76, withholding release of goods. The commissioner may withhold the release of goods for a customs procedure until A, all preconditions imposed under any law for the release of the goods have been met, B, the applicable duties, taxes, and charges under this act have been paid, and C, any security required in respect of the goods has been provided to the commissioner in accordance with Part 12. Clause 77, release notification. Goods shall be released by the commissioner for customs procedure by means of a notification in a form and manner determined by rules issued to A, the declarant, B, the operator of the customs control area at which the goods are located immediately prior to their release, and C, any other person as the commissioner considers appropriate for the exercise of any function under this act or any other customs law. And in this act, the term release notification shall be construed accordingly. Clause 78.
Mr. Chairman.
Yes.
Yes, the technical team had just wanted to emphasize the value of this provision, or to bring to the attention of the committee the shift that this represents. That's clause 77. Because you notice that clause 77 will have the commissioner notifying a number of key players when the commissioner has completed its work in relation to the release of goods. And it's our view that this is an important trade facilitation measure, and it supports other systems such as the port community system. And it allows persons who are clearing goods and even truckers and others who are engaged in the process to better organize the collection and the delivery of goods, which can save time, money, and of course, reduce frustration. It's also improved transparency as well, because sometimes we know that there are delays in the customs process, and persons may say, we don't know who to contact, right? Customs says the goods have been released, but we can't get our goods, or, somebody saying that customs may be of the view that the goods, or customs has released the goods, but the person may be receiving other information. And so this really allows persons to know, customs is essentially telling persons we've completed our activity in relation to the goods. So we are being transparent. We allow you to know. You can therefore know who to contact if you're having any difficulties in getting your goods. Maybe it's customs, maybe it's another agency, or it may be your warehouse keeper. Right? And it's also part of accountability as well, that we're allowing persons to track where we are and how well we are doing in terms of our service delivery and to raise concerns.
And then you can publish, hopefully on an annual basis, we'll see of the million, goods that came or whatever, declarations, how many of them you processed within various bands of time.
Right, we do track that information now and we use it in-house, but it means now that the public, our clients will also be directly getting those release notifications. So they too can hold us accountable to whatever statistics we may be publishing, because they may be able to say, yes, that has been my experience, or no, that was not my experience.
Yes.
So we wanted to just emphasize that this is an important shift, and, really reflects the new mindset or part of the increased efforts of customs to continue to modernize and improve.
I was watching and following very closely, and the answer provided was preemptive in a way, and I appreciate it. I appreciate it very much. Let me ask you, just in terms of this entire section or subpart, how does this will we in further on come back to address the issue that we had raised at the beginning about free circulation, and how does this dovetail with free circulation? That's a question I have in my mind now, and I want, it may not be answered, you may not be able to answer it now, but at a point in this review, the issue of free circulation, so that what my concern is that even though you have the release of the goods, the question is release for what purposes? Is it, and what a free circulation, which is really, again, the commercial part of the operation that I'm really interested to know. Not only the speed at which it's released, which is good, and I appreciate the shift, but what is the implication for free circulation?
Noted, Member Hilton. I don't believe that, as you indicated, the issues with free circulation will be resolved in these sections here, but we have certainly noted the concerns that have been raised in relation to it, and I do believe that perhaps when we've gotten a little further into the bill, we'll be able to perhaps better appreciate how it is. But in terms of generally release, it'll be released for whatever customs procedure the person had applied for.
Okay.
So release for whatever purpose the declarant had asked for.
Okay, all right, with you, but that concerns me, and I'll be watching for that.
All right, we can continue. Thank you, member.
Clause 78, delivery of released goods. 1. The operator of a customs control area commits an offense if that operator delivers goods to any person otherwise than on the authority of the release notification. 2. A person who accepts delivery of any goods from the operator of a customs control area otherwise than on the authority of a release notification commits an offense. 3, if the operator of a customs control area delivers goods otherwise than on the authority of a release notification, A, the person to whom they were delivered shall return the goods to the operator or deliver the goods to such other place as the commissioner may determine, and B, where the goods are not accounted for, the commissioner may hold the operator liable for any duty and tax payable on the goods. 4, goods released under Section 75 for a customs procedure shall, within the period applicable to those goods, by provisions made under this act regulating that procedure, be removed from the place where the goods were released. Clause 79, confirmation of release notification and delivery of goods. The operator of a customs control area who is in control of the goods released under the authority of a release notification shall promptly notify the commissioner by such electronic or other means as may be prescribed by rules of the delivery of the goods to the person entitled to take delivery of the goods under the release notification, and an operator who contravenes this section commits an offense. Clause 80, cancellation, amendment, or substitution of release notification. The commissioner may, in such circumstances and in accordance with such procedures as shall be prescribed, cancel, amend, or substitute a release notification.
Hello? Hello?
Go ahead.
Could we just go back for a second? There is the provision about that introduces the term entitled, the person entitled, yes, 79, I think. Deliver the person entitled to take delivery. Is that, and I'm talking now to the attorneys with a customer CPC, the person entitled, and this is a new introduction. I mean, this term entitlement, or the person entitled, is that the same as or consistent with the declarant? And does this person entitled introduce any new legal construct in here? I mean, we've been following the declarant and releasing to the declarant. Person entitled now, coming to it. Does that what does that introduce, if anything, new in the legal construct? Anyone from CPC or the customs can respond to that.
Anybody wants to answer the question?
I don't know your customs. I don't see where it introduced anything new. If you read the sentence, it continues to say delivery of the goods under the release notification. So it is the person to whom customs would have released the goods, or would they named in the release? So there's a connection or clarification there.
All right. So in other words, then, this have to do with entitled, meaning, as it has been described, is the word entitlement is not the same as to which that title belongs to. It really is in the common sense, not in a technical sense.
Right. It's in the sense of being as equivalent to the person who is, I mean, I guess equivalent language would have been the person who's authorized, or the person to whom the release notification, not to whom the release notification is, but the person who is, to whom the goods have been released per the release notification.
The
entitlement is not necessarily speaking to title to the goods.
Okay.
Right?
Okay.
It's likely to be the declarant, but this contemplates you could have scenarios where, the release notification, the person who's entitled to take delivery or who is lawfully able to take delivery of the goods may not necessarily be the declarant. But it will likely be so because the release notification will be pursuant, in most cases, pursuant to a goods declaration.
Mm-hmm. All right, I just wanted to flag that if they that you know that could have a wrinkle to it, but I understand. But is there a better? Would it be less in the way that it has jumped out at me? Is if we had put the person authorized, would that be a better expression of it? Anyway, just
perhaps I would prefer to.
I would just flag that and ask to be looked at. But I hear what is being said, and I hope that it doesn't introduce anything or provide any wrinkle in the interpretation of it. But I'll flag it and let's proceed.
81. Clause 81, effect of release of goods for customs procedure. Goods released for a customs procedure may not be dealt with otherwise than in accordance with the provisions of this Act and all other customs laws. Clause 82, samples. 1. An officer may take samples of any goods under customs control, A, in order to establish or verify, 1, the nature or characteristics of the goods, 2, the quality or contents of the goods, 3, the tariff classification, customs value, or origin of the goods, or 4, any other facts in relation to the goods as may be prescribed by rules. B, for use as evidence in court or other legal proceedings, or C, for any other purpose as may be prescribed by rules. 2, while goods are subject to customs control, the declarant or any person who may submit a goods declaration in respect of the goods may, with the approval of the commissioner, A, take samples of the goods, or B, perform any other action in relation to the goods as the case as may be permitted by rules. 3, an officer, A, may require the declarant, or if there is no declarant, the importer or exporter, as the case may be, to supply for any of the purposes specified in any of the provisions of subsection 1A to C, any samples, illustrations, drawings, plans, or other documents relating to the goods, and that person shall comply with the request free of charge. B, shall, unless to do so would prejudice the investigation of any crime, give at least 24 hours prior written notice to the person referred to in paragraph A, 1, of the date and time when and the place where samples are to be taken under subsection 1, and 2, directing the person to attend therefore, and if the person fails to attend as directed in the notice, the officer may nevertheless proceed to take the samples. 4, samples taken of imported goods under subsection 2 before the goods are cleared and released for a customs procedure shall, A, if the goods are subsequently cleared for a customs procedure, be treated as included in the quantity cleared for the customs procedure, and B, be treated as cleared for home use if the goods are not subsequently cleared for another customs procedure. 5, the government shall not be liable to pay compensation in respect of any sample taken under this section. Clause 83, taking of accounts. Commissioner may...
Just one comment. Whilst Minister Chairman.
Yes, member, go ahead.
Whilst can we go back to the taking of this sample and treated, right? No, come, I'm taking over on section 1. Okay, go a little, come up a little more. No, go down. The point general question I really wanted to ask, it's about, 5, it's about compensation. While I understand the provision of in protection of the government coffers and the officers, is there any requirement that the officers in this process exercise any form of diligence, or they can act in any manner, and they are protected, notwithstanding their conduct? I think it's a bit overbroad, and can anything be addressed in the regulation? I don't think that in the handling of goods, that you simply can treat with it anyway, and have protection, notwithstanding the conduct involved. I think there are cases, I think there are limits. The officer should do so in a manner that is reasonable, and have due regard for the these are goods not only for home use, but some of these goods are for commercial uses. And if in the process you don't take care, you damage them, then you're really talking about a loss to the importer of the goods. And so I'm a little concerned, Chairman, about the breadth of this protection, and that not even wanton or reckless conduct on the part of the officer can be addressed. I think we need to. I'm a little uncomfortable with 5. I think is too broad. Chairman?
This is with respect to samples. And remember, the sample here is being requested by, let's look at it again.
By the customs, by government. And that's fine. I mean, those are for different purposes, including rules of origin, and I understand that, accept that is necessary. That's a necessary part of the procedure. My concern is a narrow concern.
It's with respect to the sample, meaning that if you take a sample out, and the sample, is what we're talking about.
No, and that's my point. So a sample, I'm not expecting that we'll be able to define a sample here. You have to leave it to the judgment of the officer conducting the exercise.
No, remember, to have the government liable for a sample that it takes out for evidentiary purposes or for any of these other purposes. We couldn't have the government liable for the sample.
No. That's not, the government is not liable purely for the sample. That's not the point I'm making.
Okay.
The point I'm making is that in so doing, is there any requirement that the officer do so using non-malicious action or exercising some sort of care? I mean, they can do any whole thing to anything.
Okay, put that over to the technical team.
Right.
Should the government be required to exercise, care when handling the samples?
I can't help but think of perhaps the unusual scenario. So I know the concern that Member Hilton has raised.
And it would be unusual. I agree.
Usually whatever samples. I'm sorry?
No, I'm saying I'm agreeing with you that it would not be the normal way, but I believe that in extreme situation, that there should be there's some requirement that some care be taken, because as I've said, it's not only for consumer goods or items. Some of these are goods of trade, and will damage people's business in cases.
Right. We're not averse, I think, to probably having some guidelines, as you have suggested, being developed to guide the officers to ensure that in that unusual scenario, but nevertheless that we don't have any abuse, because that is certainly important.
Yeah, that's the direction in which I'd like for it to be considered.
In the majority of instances, though, as you would have known, a lot of times these samples are in fact destroyed in the process because they may be taken to a lab for testing and those kinds of things.
So if I may, Chair, Commissioner, Chairman.
Yes, you go ahead.
Yeah, so in just looking at the section that Member Ilton raised, the Section 5, the government shall not be liable to pay compensation in respect of any sample taken under this section. Now, the compensation is, as I see it, to my understanding, is as it relates to us taking the sample for whatever means. So it is not speaking to the sample being destroyed. And even if it is
correct.
So I'm trying to understand the context in which Member Ilton is positing.
Well, let me just, and I'm just conjuring up because my experience at custom is only limited to the complaints that I get from time to time. So I don't know how so the officers who work there and yourself, Commissioner, much better able to say. But my concern is that while it is entirely appropriate and necessary that samples be taken for the purposes you've indicated, I am saying that in doing so, particularly, and again for good reason, that the custom officer, while they may, for all kinds of reasons, may do so without any observance from the goods declarant or whomever. If they were to act in a way that is in total disregard for the protection of the good as a whole, and in the process of doing sample, the sample essentially damages the good and the effective use to which the good is intended to be used. Then I'm saying in certain situations, we need to, I think that can be looked at, and there be guardrails put in so that it's not simply that while in the main, officers would exercise due care. I believe there needs to be some sense in which the officer knows that they have to exercise good judgment and due care, because those goods we're speaking of, and we're talking about them in abstraction. Some of them are very valuable goods, extremely valuable, and the use of which they are put, if the taking of the sample, I'm not talking about the sample, the taking of the sample, where you take it from, how you do it, is not done so with some care. You can damage the good beyond its useful life. I mean, so I just think that it's overbroad, and some attention needs to be given for those extreme cases.
Without having the extreme cases dominate, meaning we don't want to set the rule. Right? So balance has to be found, right?
When it's right. I mean, the goods is for. I'm just saying it's an exception. It's the exceptional situations I'm talking about.
Mm-hmm.
I think it needs to be looked at carefully, and that can be again, it's custom supervising custom, but that's where that's where the broad experience.
Okay, remember, suppose we were to say, let's look at how other jurisdictions handle this. Let's choose a few that we have that are high traffic volumes, and
Correct.
if the committee could, not the committee, the technical team could report to the committee how other jurisdictions handle the matter of compensation for samples.
An extreme case. I'm satisfied with that, Chairman.
Okay, good.
Noted, Chairman.
Clause 83, taking of account. The commissioner may at any time cause an account to be taken of any goods under customs control. Clause 84, exclusion of liability. No action shall lie against the government or any of its officers for any loss or damage sustained by goods while the goods are in a customs controlled area, or in respect of any wrong or improper delivery of goods from a customs controlled area, except if the loss or damage occurs as the direct result of a willful act or any negligence of any agent of the government.
Well, the concerns I raised earlier. At least in 84, maybe that, so it's very broad. No action shall lie against his officers for any loss of them while the goods are in the customs control area. This 84 could be broad enough to cover the concern I have, and so it can be looked at in this case of the sample. I think it will be looked at in conjunction with this to see if this covers including the actions of taking the samples from these goods. It may be broad enough. I don't know.
Okay, noted.
Part 5, customs.
Chairman,
Yes.
I also have to raise a concern that stakeholders had raised for the consideration of the committee. It has to do with the use of the word agent there in terms of agent of government. That is, I would say, fairly standard language referring to servants or agents of the government, and it's common language found in legislation. But in this particular act, we had defined agent a particular way. And so I recall a stakeholder had raised the concern that this may pose some challenges. And on our review, we do see that indeed on a very strict reading, since agent, the interpretation section says agent means a person who's appointed in accordance with section 270, right? But we have used this expression here, agent of government, which is being used in the ordinary way in which it is used and it appears in other legislation, servants and agents of the crown.
But are you finished? Because I have a question, follow-up question. Was the concern about agent? Because here the agent is the agent of the government. My understanding is that there was that concern came up early about an agent in the definitional sense in which other actors could be classified as an agent, such as those in relation to the ship that provide services to ships or shipping, or even freight forwarders and others. But here, this is an agent of government. So would that concern apply or even arise? If I understood it correctly when it was first raised.
You're correct, Member Hilton, that the concern was raised in relation to liability for customs brokers and shipping agents. But the concern was also raised in relation to how the term is used here at 84, as well as another provision, I believe it's section 130, subsection 3, we get there, which also refers to agent of government. So it was raised in relation to both aspects.
Okay.
I just thought I'd mention it to see if the committee also felt that this was an issue that needed to be addressed.
No, I don't see an issue here.
I agree.
Very well.
Part 5, Customs Procedures. Subpart A, Goods under a customs procedure. Clause 85, Duration of customs procedure. A customs procedure in relation to goods, A, begins when the goods are released for that procedure in accordance with this act, and B, is completed when all the requirements of that procedure have been complied with. Clause 86, Transfer of rights and obligations in respect of goods under customs procedure. 1. The rights and obligations in respect of goods that are under customs procedure may be transferred in whole or in part to another person with the prior approval of the Commissioner. 2. The Commissioner shall give approval under subsection 1 if satisfied as to the transferee's ability to comply in terms of subsection 3. 3. The person to whom a transfer of any rights and obligations in respect of goods that are under customs procedure is made shall comply with A, the requirements and conditions applicable to the goods under that procedure, and B, the conditions, if any, imposed by the Commissioner in respect of the transfer, and if the person fails to do so, the person commits an offense. 4. Subsection 3 does not affect the liability of the transferor for any duty, tax, charges, penalties, or other liability owed to the Commissioner in respect of the goods up to the time of the transfer. Clause 87, deemed clearance. 1. Imported goods may be treated as if the goods are declared for home use if A, the goods are dealt with in contravention of any customs law, or B, the goods are damaged, destroyed, or unaccounted for while under that procedure, and the damage, destruction, or failure to account, as the case may be, is not attributable to a cause prescribed by regulation. 2. Upon goods being treated as declared for home use by virtue of the operation of the provisions of this Act, the duty and tax payable in respect of those goods may be recovered from the declarant, or if there is no declarant, the importer, in addition to any penalty or sanction, or any other action that may be taken under this Act or any other customs law. Subpart B, transportation of goods.
Chairman, there is clarification, an issue that the technical team just wishes to raise. Clause 87 was intended to deal with instances where goods are destroyed and how are unaccounted for and how they will be dealt with. So to the extent that at 87.1b, it says the goods are damaged, destroyed, or unaccounted for while under that procedure, those words would need to be deleted, the words while under that procedure. Because if you notice, the chapeau is saying imported goods will be treated as if declared for home use if certain things happen. So it will be inconsistent and indeed not appropriate to say while under the home use procedure, you'll be treating it as though it had been declared for home use.
Just reminding, Chairman.
Yeah,
if I
go
can,
ahead, please. Go ahead.
Yeah, and I'm following, and I had a little question, but I wasn't sure. But now that we're examining it, remind me briefly what the term, the concept of the home use is and how it's used under this Act.
So home use will be goods that are for domestic purposes. So
Right.
essentially what this provision is saying is that if you deal with goods in contravention of customs laws, we will treat the goods as though you had in fact cleared the goods for home use, and therefore all the duties and taxes and so on would flow. Similarly, if the goods are unaccounted for, they go missing, as it were, right? And it's not for any justifiable cause, and we've made provision for justifiable cause there, then essentially you are responsible for the duties and taxes, if any, that the law would prescribe. Right? So essentially we'll deem it as though you had done a goods declaration and asked for the goods to be brought under home use.
So let me just raise a general concern. And the resolution may come later on, but you are saying that if goods that are in a customs control area under procedure is damaged or go missing or whatever, then it will be deemed for home use for purposes of paying the taxes, so that notwithstanding that the person never saw the goods were never delivered, they've had nothing to do with the goods in transit, or, well, I'm using that term loosely, not transit, but the goods are in under some procedure, that they are nevertheless reliable simply by attempting to import the goods into Jamaica. Isn't that the effect of what you're saying?
I'm not sure if I understood all of the question, Member Hilton, but if a person has ordered goods and the goods did not arrive, right, they're what we call unaccounted for, we are contemplating making provision for that in this concept of attributable to a cause prescribed by regulations. Okay. So in the regulations, we will allow for those instances where goods are unaccounted for, and in those cases, where what we contemplate for those regulations is that the person would not be responsible for the duties and taxes, because we do recognize that there are instances where a person may make an order and it is short-shipped through no fault of their own.
All right, can we just flag this so that when we come to the definitions, well, you mean in regulation that you put those?
Right, this concept
define those.
Yes, the concept of attributable to a cause prescribed by regulation. So the cause would be set out in regulations.
All right, well, I'd be interested to see how the regulation treats with those. But that's ahead of us, but if we can flag that.
Yes, I noticed that the CPC.
Go ahead, CPC.
Thank you. I was just wondering, with the proposed deletion of the words while under that procedure, there would be nothing then to qualify the goods in terms of whose custody they are in, or the point in time at which the damage occurs. The provision would just then be speaking to imported goods being damaged, but you're not pinning down to a particular point in time or a particular custody. So I think you would need to replace it by some other words.
I understand the point you're making, OPC. I understand the point.
Duly noted, CPC. I believe we will need to have some further discussions with you to see how best to pin it down and to properly express the intention of the provision. Thank you for that guidance. Okay. And another observation too, and perhaps we can settle it another time as well, CPC, that we noted that in this provision, there's a reference to attributable to a cause prescribed by regulations. And we believe later in the legislation, we use the expression justifiable cause. So just in terms of harmony, it's the same provision that we are referring to in terms of setting these matters out in regulations. I believe it will be section 177, subsection 3. So just to ensure that the language is harmonized, and we say attributable to a cause or perhaps we need to have attributable to a justifiable cause here to make it consistent with 177, or we amend 177 to delete justifiable cause. Our recommendation is to use this language of justifiable cause prescribed by regulations.
Correct. I agree with that.
Well, I don't think that you should use both. If it is that you want to prescribe, then you could just refer to regulations itself, because once you start to use the word justifiable, you're going to have to show or demonstrate. It opens you up to the argument that what you have set out in the regulations might not be justifiable cause. So I would prefer if you had not, we don't use justifiable.
Okay. Correct.
Very well, CPC. So we will leave it here then, and then we would, when we get to clause 177 at subsection 3, make that adjustment as well to delete justifiable cause there.
Right.
Noted with thanks.
Subpart B, transportation of goods. Clause 88, procedure for transportation of goods not in free circulation. 1. Goods not in free circulation may be transported in or through Jamaica only in accordance with this act, and a person who transports goods in contravention of this subsection commits an offense. 2. Where necessary and without prejudice to any other power exercisable by the Commissioner may take any steps or issue any directions to guard against any unauthorized interference when goods not in free circulation are transported, including A, affixing any marks or seals to the vehicle or container in which the goods are to be transported, B, stipulating the specific place to which the goods shall be delivered, C, requiring the provision of security in keeping with the provisions of this act, D, requiring that the goods be transported under the supervision of a customs escort in any case where the Commissioner determines that such an escort is necessary for the enforcement of the provisions of this act, and a person who fails to comply with any such direction commits an offense. 3, the rules may prescribe the form of and circumstances in which a report in respect of any goods transported under subsection 1 may be required. Clause 89, accidents and other unforeseen events. 1, the carrier or other person transporting goods not in free circulation shall make a report to the Commissioner in the form and manner and within the time prescribed by rules in respect of the occurrence of any breakdown, accidents, or other unforeseen events in the course of transporting the goods, which compromises the integrity of the goods, and a carrier or other person, as the case may be, who fails to do so commits an offense. 2, for the purposes of this section, rules shall prescribe the circumstances that are deemed to constitute events which compromise the integrity of goods. Clause 90, transfer of goods between means of transport. 1, goods may be transferred from a foreign-going vessel or foreign-going aircraft to another means of transport, whether a vessel, aircraft, or otherwise, A, in accordance with a customs procedure that allows such transfer, or B, as permitted by the Commissioner in accordance with rules. 2, once the transport of goods that are not in free circulation has commenced, the goods may be transferred from the means of transport in which the goods are transported to another means of transport only, A, in accordance with this act and the terms and conditions governing the transportation, or B, with the permission of the Commissioner. 3, a person who transfers goods other than in accordance with this section commits an offense.
Let me just congratulate the customs for really addressing one of those long-standing problems. And this looks workable. I'm awaiting to see what the rules, the regulations, subsidiary regulations are. But seems to me that this addresses one of the big issues that have really constrained commerce, and particularly logistics operations in Jamaica for a long time. So I'm pleased to see that.
Noted. There are some stakeholder comments, but it's on the procedure. But let's get through the procedure first before bringing them up. Okay. So I think we get from 91 down to 94, I believe.
Okay.
Subpart C, transit procedure. Clause 91, national transit. 1. In respect of goods under customs control, the transport of those goods from one customs controlled area to another customs controlled area, hereinafter referred to as national transit, shall be conducted in accordance with the provisions of this Act, the regulations, rules, and any other applicable customs laws concerning the transport and sealing of goods under customs control. 2.
Chairman?
Yes. Yes, AG?
Am I recalling correctly that some concern was raised as to whether provision in respect of national transit seemed overly bureaucratic? I don't know if I am recalling clearly or if anyone has a similar recollection, and if there is any need to just take a little closer look at the provision. Not sure. If I'm recalling exceptionally, then we may proceed. If anyone shares the observation.
Yeah, I share it. I think the chairman also does. He was saying, let's go through all the sections and then before we come back to those comments or concerns. But I think you're correct, AG.
Thank you, Member Hilton. Right.
2. The Commissioner may require that security be given in accordance with the provisions of Part 12 for any goods undergoing national transit. Clause 92, transit to export. Where goods are imported into Jamaica for the purpose of transport through Jamaica to a customs controlled port or other customs controlled area for export, the goods in this Act referred to as transit to export goods shall be dealt with in accordance with the procedure for transit to export set out in this Act. Clause 93, transportation of goods. 1. The transportation of goods for the purpose of national transit or transit to export shall not commence until the goods are released for that procedure, and a person who transports goods in contravention of this subsection commits an offense. 2. The transportation of goods under customs control shall commence and end at a customs office or such other place as may be permitted or directed by the Commissioner. 3. Person shall not, without the prior written permission of the Commissioner, redirect goods from any place specified in the goods declaration to be the place at which the transportation of goods commences or ends. 4. The transportation of goods under customs control shall be carried out in accordance with such terms and conditions as the Commissioner may specify in accordance with rules. 5. Where the transportation of goods under customs control ends, A, at a customs controlled area that is not a customs office, the operator of the customs controlled area shall immediately notify the Commissioner in the event of any failure of the goods or any portion of the goods to arrive at that area. B, at a customs office, the proper officer shall acknowledge delivery of the goods. 6, the transportation of goods under customs control is completed when the goods are acknowledged as delivered at delivery point indicated in the transit declaration, and upon such completion, the carrier in respect of the means of transport or the declarant concerned shall, if required by the Commissioner, A, submit to the Commissioner proof in such form and manner and within such time as may be prescribed by rules that the transit procedure has been completed, and B, comply with such other requirements as may be prescribed by rules for the purposes of this subsection. 7, the responsibility for ensuring that the transportation of goods under customs control is carried out and completed in accordance with this act shall rest with the declarant. 8, a person who transports or redirects goods in contravention of this section or who fails to comply with subsection 5 or 6 commits an offense. Clause 94, use of transport document as goods declaration. For the purposes of this section and sections 93 and 95, with the approval of the Commissioner, a transport document issued in respect of goods may be submitted to the Commissioner as the goods declaration in respect of those goods for the purpose of clearance for the relevant procedure if the transport document contains the information required under this act to be contained in a goods declaration in respect of those goods.
And just read 95. Let's read 95.
So Part D, transshipment procedure. Clause 95, clearance of goods for transshipment. 1, goods shall not be transferred for transshipment unless the goods are released for transshipment. 2, if imported goods are not transshipped within 90 days after their arrival in Jamaica, or such longer period as may be prescribed in the regulations, those goods shall be dealt with in accordance with the provisions of Subpart F, goods at a government warehouse. 3, the Commissioner may, A, take any steps or issue any directions necessary to identify goods that are subject to transshipment procedures and to guard against any unauthorized interference with the goods while in Jamaica or during the transshipment of the goods out of Jamaica. And B, prescribe conditions or specifications to be observed with respect thereto. 4, a person who transfers goods in contravention of subsection 1 or fails to comply with a direction, condition, or specification imposed under subsection 3 commits an offense.
Okay, Ms. Adams, you want to go through what the stakeholder comments were in this area?
Yes, Minister. The comments relate to, well, 91, clause 91, 92, 95. The stakeholders had expressed the view that the provisions appear to create artificial distinctions between transit at clause 91, transit to export at clause 92, and transshipment at clause 95, as well as coasting trade. They had raised some concerns in relation to that 172, and coasting trade, of course, has to do with the movement of goods by sea. And so they felt that all of these provisions treat with movement of goods and that the distinctions were artificial. The view was also expressed that the changes that are being proposed in the legislation are likely to hinder rather than foster the growth of the logistics business and will likely involve increased bureaucracy. Stakeholders also expressed the view that, in their opinion, The distinctions made here are more appropriate in landlocked countries, and the definitions now inserted in the Act will likely create confusion by drastically changing both the terminology associated with the activities as well as the nature of the activities themselves. The stakeholders also indicated that they would wish to have a clear indication of what would be provided in the rules, as there are possible implications for cost and efficiency, depending on the terms and conditions that the commissioner may impose, such as, for example, the conditions that the commissioner may impose in relation to inspection, the use of escorts, and so on. And I believe that summarizes the comments of the stakeholders in relation to these provisions.
My observation is I share the general concern of the stakeholders. I think the resolution, whether the definitions are distinction without a difference or is likely to confuse, I think we'll have to see how the regulations apply to them to be able to make a true assessment. But I think the concerns do arise, and we need to pay special care and attention to see how they are resolved.
Yeah, I would share what you're saying, Member Hilton. I mean, we're going to need the distinctions in order to create the nimbleness, right? You know,
right.
You can treat things separately and differently.
Right.
But whether or not it becomes cumbersome depends on how those regulations are written.
Right. Correct.
You know,
Correct.
this on the surface by itself does not disqualify it on the basis of it being cumbersome. In fact, this sets us up to have a nimble arrangement.
Quite possible.
Yeah. All right, yeah, and as we had said, we won't be taking this, you know, and I know this is really a very a commitment that puts some pressure on customs and CPC and so on, but we won't be taking this this bill even after it goes to the joint select without having the regulations completed at the same, you know, ready. For reasons such as this.
Yeah, I fully support it, Chairman.
Yeah. All right, 96.
So Chair.
Yes.
Chairman, just to add, as it relates to logistics, you would appreciate that customs operate within a rule-based, procedural base, and even within our main customs management system, ASICUDA. It's operate by way of regimes, you know, and procedure codes. Now, I say this against the background within logistics is that, you know, the logistics continues to evolve, and many people have different meaning and different way of operating, and they will call it logistics, and rightly so. And so it poses space for us. How do we, you know, put in place certain regime operationally to facilitate the nimbleness, the fluidity to which that sector requires? And what we have been doing, Chairman and members, is having the dialogue with the different logistics operators to understand their business and to see how best the agency can continue to respond, right? So I do take the members' Hilton's concern and yours to share in us, you know, continuing to look and to make it as easy as possible, well, and also not compromising on any of the laws that we have to enforce within the space as well. Thank you, Chair.
Okay.
And Commissioner, I just comment just to say, I think I understand it, and as the Chairman pointed out, it's a tall order, but if we get it right, then I think it will redound to the benefit of the economy as a whole and competitive firms and Jamaica's position. And in order to even attempt to do that, I think the exercise you're engaged in is critical. And it's not expected that you come up with a rule to address every firm's particular situation, but I think it is to yield the best practices and to see how best to accommodate all of those concerns while taking into consideration your own responsibilities under the broad regime. So it's an exercise that is challenging, yes, perhaps time consuming, but I think if we get it right, then we'll begin to fix the economy in particular ways. So I encourage you to, just to stay the course and to continue the consultation.
Certainly, certainly.
All right, let's continue.
Well, clause 96, responsibilities for ensuring compliance with transshipment requirements. 1, where goods at a customs controlled area are to be loaded on board a vessel or aircraft that will transport the goods out of Jamaica pursuant to a transshipment procedure, the following person shall immediately notify the commissioner if goods are removed from a customs controlled area for a purpose other than the loading of the goods on board a vessel or aircraft. A, the declarant concerned. B, the operator of the customs controlled area. 2, the report submitted in respect of goods by the operator of the customs controlled area pursuant to section 53 shall in respect of goods under transshipment procedure, A, declare that the goods to which it relates are transshipment goods, and B, reflect all the information to be included in a report in relation to such goods. Subpart E, warehousing procedure. Clause 97, warehousing. 1, the minister may, by notice published in the Gazette, declare what type of goods shall be warehoused under this subpart. 2, subject to subsection 1, goods may be warehoused in accordance with this subpart and in accordance with such regulations as may be prescribed. 3, for the purposes of this subpart, references to a warehouse keeper include the owner or occupier of customs controlled area. 4, where any goods released into the custody of any person for the purpose of being warehoused, A, are not duly warehoused, or B, which, after being deposited in a customs controlled area or duly warehoused, are at the instance of any person, 1, removed, or 2, transferred from one package to another without the permission of the proper officer, that person commits an offense. Clause 98, payment of duty and tax on revocation of approval of warehouse. 1, where the commissioner revokes authorization for a place to be used as a customs private bonded warehouse or customs public bonded warehouse, A, the commissioner shall cause a notice in writing of the revocation to be given to the warehouse keeper, and B, as from the date of such notice of revocation, the duty and tax on all goods warehoused therein becomes due and payable, unless within such time as is specified in the notice, the goods are exported or are removed to another warehouse. 2, a notice in writing of a revocation referred to in subsection 1, addressed to the warehouse keeper, and A, affixed in a conspicuous place at the warehouse, and B, published in any daily newspaper in circulation throughout Jamaica, or by such other means as would reasonably cause the notice to come to the attention of the public, shall be deemed to be notice thereof to all persons interested in the goods. 3, goods on which duty and tax is due and payable under subsection 1 and which have not been exported or removed pursuant to that subsection may be taken to a government warehouse by an officer and may be sold or otherwise dealt with, and the proceeds applied as if they were goods which might be sold or otherwise dealt with. 115. Clause 99, goods to be warehoused in import packaging. 1, goods shall not be warehoused other than in packages in which they are imported, except as provided in subsection 2. 2, goods that are permitted to be unloaded on the quay or bulked, sorted, lotted, packed, or repacked in a warehouse may be deposited in a warehouse in packages in which they are contained at the time when an account is taken of them on the completion of taking of account. 3, after goods are warehoused in a customs private bonded warehouse or customs public bonded warehouse, the following actions may be taken only with permission of the Commissioner. A, any alteration to the goods or the packaging of the goods, or B, any alteration to any mark or number appearing on the packaging of the goods. 4, a warehouse keeper who contravenes or permits a contravention of this section, and any other person who contravenes this section commits an offense. Clause 100, storage of goods.
Chairman,
Go ahead.
in our review, the technical team looked at the use of the word, I believe it's key, at 99.2, and we're proposing replacing it with customs controlled area. Partly because the language is somewhat archaic, and certainly in the interpretation section, there's no guide as to what this is. Known in customs circles that is in the past would have been perhaps equivalent of what we would have now considered to be a place of unloading or offloading of goods.
99.2?
99.2. The proposal is to replace that word key
with customs control area. Goods that are permitted to be unloaded in the customs control area?
Yes.
In a customs control area.
In a customs control area.
Okay, any issues with that? All right, let's move on.
Clause 100, storage of goods. 1, the Commissioner may direct A, the manner in which goods are to be deposited in a warehouse. B, the part of the warehouse or customs controlled area in which the goods are to be deposited. And C, the manner in which access may be had to the goods, being reasonable access in all the circumstances. 2, where direction of the Commissioner under subsection 1 is not complied with, A, the Commissioner may send to the warehouse keeper a written notice requiring the warehouse keeper to comply with the directions within a period of 7 days, excluding Saturdays, Sundays, and public general holidays from the date of the notice. And B, a warehouse keeper who fails to comply in accordance with a notice issued to that person within the period specified in the notice commits an offense. 101, transfer between warehouses. 1, the transfer of goods between warehouses shall be conducted only in accordance with the regulations. 2, notwithstanding subsection 1, the Commissioner may remove goods from one government warehouse to another government warehouse in any manner that the Commissioner considers reasonable. 3, where goods are transferred pursuant to this section, A, the person who caused the goods to be transferred shall give security in accordance with Part 12, and B, a record of all goods transferred to and from the warehouse shall be kept by the warehouse keeper and shall be furnished to the proper officer upon request. 4, a security under subsection 3 shall not be discharged unless A, the full duty and tax has been paid on the goods, B, the goods have been accounted for to the satisfaction of the commissioner, or C, the full duty and tax on such portion of the goods as is unaccounted for has been paid. 5, upon arrival of the goods at the warehouse to which they are transferred, they shall be warehoused in accordance with the customs laws. 6, notwithstanding subsection 5, on arrival of goods at the warehouse to which they have been transferred, the declarant may, without actually warehousing the goods, clear the goods for home use or another customs procedure after the goods are accounted for in accordance with this act. 102, stores. 1, the commissioner may permit warehouse goods to be removed and delivered as stores to A, a foreign going vessel, or B, a foreign going aircraft in accordance with Subpart 1 of this part. 2, where goods removed for delivery for a purpose specified in subsection 1, A, are not duly placed on board the foreign going vessel or foreign going aircraft concerned, B, are dealt with in contravention of a customs law, or C, are not otherwise accounted for to the satisfaction of the commissioner without prejudice to any penalty that may be applicable, the duty and tax in respect of the goods shall be payable by the person to whom the permission was granted under subsection 1. (103) Duty and tax to be paid according to original account. The duty and tax to be paid when warehouse goods are declared for home use shall not be less than the amount payable on those goods according to the value or quantity thereof, as the case may require, at the time the goods declaration for the warehousing of the goods was registered. 104, records and accounts. Where imported goods are cleared for the warehousing procedure, the warehouse keeper of the warehouse at which the goods are deposited shall A, take account of the goods, notwithstanding that the goods may have been taken account of on arrival at the quay or elsewhere, and B, keep such records in relation to the goods and provide such reports and other information thereon as the commissioner may require.
Chairman, just again proposing that the word key be removed here and perhaps replaced with at a customs control area, just as had
to be consistent with what we did a while ago. No? Yeah.
Before.
Clause 105, re-warehousing in customs bonded warehouse. 1, this section applies only to goods warehoused in a customs private bonded warehouse or customs public bonded warehouse. 2, unless re-warehoused in accordance with this section, warehouse goods shall, within 1 year after the date of release of the goods for warehousing, be cleared for another customs procedure. 3, goods that are not re-warehoused or cleared, as described in subsection 2, shall be dealt with in accordance with subsection 9. 4, the warehouse keeper, in respect of goods that are not cleared within the time specified in subsection 2, shall effect the re-warehousing of the goods by taking a new account of the goods and paying the duty and tax found to be payable in respect of any unaccounted for deficiency between the quantity originally warehoused and the quantity found to exist on the taking of the new account, together with the necessary expenses and charges incurred in respect of the taking of account and re-warehousing. but less any allowances permitted under the customs laws. 5. The re-warehousing of goods under this section shall A, be done only with the prior approval of the Commissioner, and B, not exceed a period of 2 years from the date of release of the goods for warehousing. 6. Notwithstanding subsection 4, the warehouse keeper may, with the prior approval of the Commissioner, dispense with the taking of a new account for the purpose of re-warehousing. 7. The Commissioner shall grant approval under subsection 6 if the Commissioner determines that the taking of a new account is not necessary because the Commissioner is satisfied that the goods are in the warehouse. 8. Goods shall not be eligible to be re-warehoused under this section unless the proper officer certifies that the goods are in suitable condition to be re-warehoused. 9. Where goods, A, required to be warehoused under subsection 4 are not re-warehoused, B, are not eligible to be re-warehoused and are not cleared under subsection 2, or are re-warehoused and the time specified under subsection 5 has expired without the goods being cleared for another customs procedure, the goods shall be disposed of pursuant to section 115.
Sorry. Note, Chair, that those words beginning from the words "the goods shall be" should go back to the margin of the subsection, because they govern both A, B, and C.
Understood.
10. The proceeds of sale, if any, pursuant to the power of disposal under subsection 9, shall be applied in the manner specified in section 122, application of proceeds of sale. Clause 106, warehousing for processing or manufacture. 1. Notwithstanding anything to the contrary in this act, and subject to the provisions of the Excise Duty Act, the Commissioner may, subject to such conditions as the Commissioner thinks fit to impose, either generally or in any particular case, permit goods to be warehoused at a customs private bonded warehouse or customs public bonded warehouse for the purpose of being processed, for example, by manufacture, repair, sorting, packing, consolidating, or deconsolidating. 2. Permission granted under subsection 1 may be in respect of goods A, that are not liable to import duty and tax, or to excise duty and tax, B, on which import duty and tax is payable or has been paid, or C, on which excise duty and tax is payable or has been paid in such quantities as the Commissioner may specify. 3. Goods processed under subsection 1 shall be subject to the provisions of the customs laws applicable to warehouse goods. 4. Nothing in this section shall be construed as permitting inward processing or outward processing to be carried out other than as permitted under Subpart L. Subpart F, government warehouses. Clause 107, operation of government warehouse. A place that is designated under section 31F to be a government warehouse shall be operated by the Commissioner or by another person with the written approval of the Commissioner and subject to such terms and conditions as the Commissioner shall, in accordance with the rules, specify in the approval. 108, removal of goods to government warehouse. 1, the Commissioner may deposit goods or cause goods to be deposited in a government warehouse at the expense of the declarant, or if there is no declarant, the importer or exporter, as the case may be. A, if the goods are imported. If the goods are imported goods required to be cleared in accordance with this act, and the goods have not been cleared within the time specified under this act. B, if goods are required under any customs law to be exported, and the goods have not been exported within the time specified in the applicable law. Or C, if the goods, one, are subject to a lien under this act, two, are detained, seized, or confiscated by the Commissioner under this act or any other law, or three, for any other reason are required to be secured by the Commissioner pursuant to this act or any other law. Two, the Commissioner may, for the purposes of subsection 1, determine the government warehouse to which goods shall be deposited. 3, a person who, without the authorization of the Commissioner, redirects goods to which subsection 1 applies to a place other than a government warehouse commits an offense. 4, if goods referred to in subsection 1 are of a kind not permitted by law to be deposited in a government warehouse, the Commissioner shall deal with the goods under section 119, urgent sales.
Mr. Chairman?
Yes.
I should have just pointed this out at the very beginning, but just for context for the members of the committee, the references here to government warehouse are the spaces that are now known as the Queen's Warehouse. So that is the context of these provisions.
Understood.
109, goods deemed deposited in government warehouse. 1, where A, goods are required under any of the customs laws to be deposited in a government warehouse, and B, for any reason, the Commissioner determines that it is undesirable or inconvenient to deposit the goods in a government warehouse, the Commissioner may direct that the goods be deposited at some other place, and from the date of such deposit, the goods shall be deemed to be deposited in a government warehouse. 2, the declarant in respect of goods deposited in a place other than a government warehouse, pursuant to subsection 1, or if no goods declaration was registered, the importer or exporter, as the case may be, shall pay to the Commissioner such charges as the Commissioner considers reasonable to recover as the expenses for securing the goods and guarding against any contravention of the customs laws in relation to the goods. Clause 110, 1, subject to subsection 2, the Commissioner, A, may do all acts which the Commissioner considers reasonably necessary for the proper custody and preservation of goods warehoused at a government warehouse or deposited at a customs controlled area occupied or used by the Commissioner, and B, shall have a lien on the goods in respect of which action is taken by the Commissioner under paragraph A. 2, the Commissioner shall not act under subsection 1 unless notice has been given to the declarant, or if there is no declarant, the importer or exporter, as the case may be, that a specified action is required to be taken by the declarant, importer or exporter, as the case may be, in respect of the goods, and 24 hours have elapsed after giving of the notice without the specified action being taken. 3, where subsection 2 applies and the Commissioner acts under subsection 1, the declarant, or if there is no declarant, the importer or exporter, as the case may be, shall be liable to pay to the Commissioner such amount in such time and in such manner as the Commissioner may specify by notice in writing, being the reasonable expenses incurred by the Commissioner in taking the action concerned. 4, where the amount specified in a notice under subsection 3 is not paid to the Commissioner in accordance with the notice, the goods concerned may be sold or otherwise dealt with, and the proceeds applied as if the goods were goods that might be sold or otherwise dealt with pursuant to section 115. 5, the Commissioner may act under subsection 1 before giving the notice under subsection 2, or before the time specified under subsection 2 has elapsed, if the commissioner is satisfied that immediate action is necessary such that prior notice may be dispensed with. (111) Charges for goods in a government warehouse. 1. The charges applicable in respect of the storage of goods in a government warehouse shall be prescribed by the minister by order published in the Gazette, being A, the charges payable for rent at a fixed rate, B, any additional charges in respect of the goods, including where goods require special care or treatment, and such an order may provide for the type of goods that are exempt from the charges referred to in paragraph A or B. 2. Rent and additional charges under subsection 1 are A, payable by the declarant in respect of the goods, or if no goods declaration was registered, the importer or exporter, as the case may be, and B, payable to the operator of the government warehouse or to the commissioner in the case of a government warehouse operated by the commissioner. 3. If goods are sold under section 118, sale of listed goods, or 119, urgent sales, any amount owed under subsection 2 to the operator of the government warehouse may be recovered from the proceeds of the sale in accordance with section 122. 4. Where any rent or charge payable under subsection 1 in respect of warehouse goods is not paid to the commissioner when due and payable, the commissioner may direct that the goods be sold in accordance with section 121, manner of sale, or otherwise dealt with in accordance with section 123, disposal of goods other than by sale. 5. The power of sale under subsection 4 is without prejudice to any other power or remedy available at law. 112. Retention of goods at or removal of goods to designated premises other than government warehouses. 1. Where goods are required to be stored at or removed to a government warehouse, the commissioner may direct or authorize the operator of the customs controlled area where the goods are located, or any person in physical control of the goods, to A, retain the goods for a specified period at designated premises, or B, remove the goods to any designated premises. 2. The provisions of this act relating to government warehouses, including sections 84, exclusion of liability for wrong delivery, and 111, charges for goods in a government warehouse, apply to any premises where goods are retained or to which goods are removed under subsection 1, as if those premises were a government warehouse. 3. Goods retained at or removed to any premises under subsection 1 shall for accounting purposes be recorded in the accounting records of such government warehouse as may be determined by the commissioner, being a government warehouse operated by the commissioner. 4. The commissioner shall give notice to the occupier of premises where goods are retained or to which goods are removed pursuant to subsection 1 that A, subsection 2 applies to those premises for as long as the goods remain on those premises. B, the goods shall be kept secured on those premises in accordance with such laws as apply to goods kept at a government warehouse. And C, the goods are, for accounting purposes, recorded in the accounting records of the government warehouse specified in the notice. 5. When goods are delivered to any premises in compliance with a direction issued under subsection 1B, the occupier of those premises shall notify the commissioner of the fact of such delivery, and an occupier who fails to do so commits an offense. 6. If a person to whom a direction or authorization under subsection 1B is issued fails to give effect to the direction or authorization to remove the goods to designated premises specified in the direction or authorization, the commissioner may, at the expense of that person, remove the goods to the premises. 7. A person to whom a direction or authorization is issued under subsection 1B may recover any expenses incurred by that person under subsection 1 or 6 in respect of removing the goods to the designated premises from A, the declarant, or if there's no declarant, the importer or exporter as the case may be, or B, the proceeds of the sale of the goods in accordance with section 122, application of proceeds of sale. 8, a person who, without the permission of the commissioner, redirects or removes goods from premises designated under subsection 1 commits an offense. 113, responsibilities of occupier of premises where goods are kept. The occupier of premises designated under section 112.1 where goods are retained at or removed to pursuant to a direction or authorization under that section shall take all reasonable steps to safeguard the goods against damage, destruction, or loss, and if the occupier fails to do so, the occupier commits an offense. 114, disposal of goods released, sold, or reclaimed. 1, where any goods that are released from a customs procedure or that have been sold at public auction pursuant to any customs law remain in a government warehouse more than 7 days after the date of release, the commissioner may impose charges at such rate as may be prescribed for the storage of the goods and may withhold the delivery of the goods until the charges are paid. 2, subsection 1 shall not apply in any case where the commissioner is satisfied A, as to the reason for the goods remaining at the government warehouse, and B, that arrangements are made for their removal as soon as is practicable. 115, publication of list of goods for disposal. 1, where the commissioner intends to dispose of goods pursuant to a power of sale or disposal under this act, the commissioner shall publish a list of the goods in a daily newspaper in circulation throughout Jamaica, and may also publish the list using such other means as the commissioner considers appropriate to bring the proposed sale or disposal to the attention of the public. 2, the list referred to in subsection 1 shall include a statement in terms of subsection 3, and if readily available to the commissioner, A, the description of the goods, including 1, the quantity thereof, and 2, the marks and identification numbers on the goods, B, the name of the carrier who transported the goods, C, the transport document number of the goods, D, in the case of imported goods, the date of arrival, E, the date of intended export in the case of goods to be exported, F, the name of the customs broker or declarant in respect of the goods, and G, the name of the government warehouse where the goods are kept, or in the case of goods retained at or removed to other premises, the physical address of those premises, and any other information the commissioner considers relevant for the purposes of this section. 3, a list published under subsection 1 shall state that the list serves as public notification that the goods on the list may A, be sold or may already have been sold under section 119 urgent sales, if that section applies to the goods, B, be disposed of under section 123, if that section applies to the goods. 116, claiming goods in or accounted for in a government warehouse.
Chairman, just to raise the issue, I believe a stakeholder, the brokers had raised the concern about their names being, the name of the broker being published. And so clause 115.2F to delete the words in accordance with their request, which the technical team has no objections to, deleting the words the customs broker or. So it would only be publication of the name of the declarant.
Okay, I don't see any objections to that. All right, let's move on.
116.1. A person entitled to clear goods deposited in a government warehouse may, within such time as may be prescribed by rules, being a time no later than 21 days after the date of publication of a list under Section 115 in respect of those goods, claim the goods by A, submitting the goods declaration required under this Act in respect of the goods, and B, complying with such other requirements as are applicable for the release of the goods under the customs laws. 2, subsection 1 does not apply in respect of goods that A, are or have been dealt with under Section 119, B, have been seized or confiscated, or C, are to be destroyed under any requirement of the customs laws. Three, goods shall not be released under subsection 1 unless all claims referred to in section 122(1)(a) to D in respect of the goods have been paid. 4, if the commissioner releases goods claimed under subsection 1, the person claiming the goods shall cause the goods to be removed from the government warehouse or other premises where the goods are kept within 7 days after the date of release. 117, proof of payment of charges required for delivery of goods. The commissioner shall refuse to deliver any goods claimed or sold from a government warehouse for any purpose under this Act unless proof is given to the officer's satisfaction that all applicable rents and charges in respect of the matters referred to in section 122(1)(a) to D have been paid. 118, sale of listed goods. The commissioner may sell goods specified in a list published under section 115 after the expiration of 21 days following the first publication of the list specifying those goods in accordance with section 115. A, if the goods were not claimed, released, or removed under section 116 or 125 within the applicable time under those sections, or B, if the goods are confiscated or abandoned goods. 119, urgent sales. Notwithstanding sections 161 and 118, the commissioner may immediately sell goods referred to in section 108(1)(a), B, or C. A, if those goods are of a perishable or dangerous nature. B, if the goods are of a kind not permitted by law to be deposited in a government warehouse. Or C, if a delay in the sale of the goods would result in the diminution of their value such that the proceeds would not be sufficient to cover claims referred to in section 122(1)(a) to D as may be applicable to the goods. Clause 120, goods excluded from power of sale. No power of sale under this subpart shall apply to goods that pose a risk to public safety, public health, or public morals. (121) Manner of sale. Goods may be sold under section 105(9), 111(4), 118, or 119 by the commissioner, by public auction or private treaty. 122, application of proceeds of sale. 1, the proceeds of the sale of goods under this part shall be applied to pay the following claims in the order indicated. A, first, toward the duty, taxes, penalties, fees, and other charges payable on the goods under this Act or any other law. B, second, toward expenses incurred by the Commissioner in connection with the goods, including expenses connected with their removal, storage, advertisement, and sale. C, third, toward amounts payable as rent and charges in respect of the goods to a government warehouse or the occupier of premises designated under Section 112(1). Fourth, towards expenses payable to a person under Section 112(7). E, fifth, towards charges payable to the operator of a customs controlled area. F, sixth, towards charges payable to a carrier of a vessel or aircraft in connection with the goods. 2, any surplus remaining after all claims under subsection 1 have been met shall be paid to the declarant, or if there is no declarant, the importer or exporter, as the case may be, A, on written application by that person in accordance with subsection 3, or B, if no application is made under paragraph A, but the Commissioner is able, through reasonable effort, to effect the payment, and any sums remaining unpaid after 1 year from the date of the sale of the goods shall be paid into the consolidated fund. 3, an application under subsection 2 shall A, be supported by proof of that person's claim to the goods, and B, be submitted to the Commissioner within 1 year after the date of the sale of the goods. 4, subsection 2 does not apply to abandoned goods, and any surplus remaining in respect of the sale of such goods after all claims under subsection 1 have been met shall be paid into the consolidated fund. 5, for purposes of subsection 1E and F, the operator and carrier concerned shall submit their claims to the Commissioner in such time and manner as shall be prescribed by rules.
Mr. Chairman, just to make one or two more technical edits, at section 122(2)(b), if no application is made under paragraph A, but the Commissioner is able, through reasonable effort, to effect the payment, and any sums remaining unpaid, I believe that should perhaps be unclaimed after 1 year.
Yes.
Or other language, as the CPC may suggest, because the idea there is that if no one claims the money, I'm not sure, perhaps we should, the idea is that we have not paid out the funds to someone, or the person has not come to claim the funds from us. I'm wondering if using the word unpaid there accurately conveys that intention.
I think the use of the word unpaid there was intended to capture also the scenario in B, because no application would have been made there, but the Commissioner is able to, although, all right, in those circumstances, the payment would have been effected. Okay, fine.
I'm looking back at it, I'm indeed seeing at the chapeau to 2. It does say any surplus remaining after all claims under subsection 1 have been made shall be paid to the declarant. And so I suspect that's why we would have used the expression if it remains unpaid. But a concern had been raised in some consultations, and I was wondering whether we needed to clarify it.
Okay, I have no objection to that.
And I'm not sure if now is the time to raise it, Minister, but and I wondered if it would be best to make any other suggestions after we've gone through all the provisions, so we can see how any suggested amendments will impact other provisions. But at section 121, the technical team, after further discussions and particularly concerns from stakeholders that have been raised to us, is proposing the removal of the reference to our private treaty at 121. And so the effect of the provision would be that all these goods will need to be sold by public auction, being, as it were, one will say the gold standard to some extent, and giving a high level of transparency in relation to the disposal of these goods that, you know, would have otherwise been owned. Well, these goods which are owned by persons that customs happens to be selling.
I'm in support of that. I'm in support of that, Chairman.
Sounds good to me as well.
The other proposed adjustment is, I believe we may need to insert another provision, that's 110 subsection 4 in the list of provisions, because when we looked back at it, there's the power to the commissioner under clause 110 subsection 4 to dispose of goods, to recover expenses. So I believe perhaps we need to insert it in this list.
Chairman, unfortunately, I'm going to have to take leave.
Yeah, we're coming up on that time.
That makes two of us, Chairman. I had messaged you quietly. I regret that
my members are watching the clock.
No, I just have
some other engagement.
And Chairman, before I go, I'd just like to ask you to look at a WhatsApp message I sent you earlier in the afternoon.
Look at mine in the process too, please.
There you go.
Although it was really just a signaling that I would be skipping out.
Albin said you'll come late but leave early.
No. You should never advertise propaganda like that.
Sorry.
Member Hilton, I'm here.
I won't resist that reinterpretation.
Okay.
All right, Ms. Edwards, where you want to finish that point you're making?
It was just to suggest in the list at 121 that we insert.
Oh, right. Yes, I got that. We got that. Yeah. All right. So where were we in the middle of a clause? We might as well just finish that clause.
No, we had ended a clause and we had just ended 122, Minister.
Okay. All right. Well, I'm about to lose my quorum. It is.
Yes, Chairman, I'm about to skip out.
Yes, and it is 5 o'clock. The last two meetings.
It's a convenient time.
It's a convenient time. We went beyond the last two meetings to 5:30, but on this occasion, given the need to depart.
And you pressed gas this time today, Chairman.
Huh?
You pressed gas today.
Pressed gas today, exactly. We made good ground. But you know, it's 300 clauses in all.
Yes.
So still have a ways to go. But this was good progress today. Our next meetings, we can get to that point in the agenda. Date of next meeting, I believe, Ms. Bailey, is sometime in July.
July 1st, Chairman.
1st of July. So that's 2 weeks from today.
I move the motion of adjournment.
So can we have a next meeting July 1st, Thursday at 2 p.m. All in favor?
Aye.
Okay. And let's move in the motion of adjournment proposed by Member Malou Fort, seconded by Member Hilton. All in favor?
Aye.
All right. Good day. Have a good day. And see you 2 weeks from today, tomorrow. 2 weeks from tomorrow. Take care.
Okay.
Bye-bye.
Very well. Good afternoon, everyone.
Good afternoon.